Morning, everybody. I'd like to call to order this hearing of the Senate Judiciary Subcommittee on Immigration, Citizenship, and Border Safety. Before beginning today's hearing, I do want to take a moment simply to acknowledge the settlement between the Biden administration and the plaintiffs in the Missel family separation litigation that was announced earlier this week. While nothing can fully undo the harms that the zero tolerance created, this settlement will provide critical safeguards against a future family separation policy. It's not the specific issue at hand today, but I think relevant enough, noteworthy enough to reference in this morning's hearing as we begin. But we are gathered here for what is the second hearing of the subcommittee this year. I want to thank Ranking Member Cornyn for prioritizing today's hearing, all the staff who made this hearing possible, and everybody's flexibility with the timing of the hearing, given other matters before the Senate today. We're here to examine the current state of our nation's immigration courts, which are charged with adjudicating immigration cases by fairly, expeditiously, and uniformly interpreting immigration laws. Every day, judges like Judge Sankoff, who is here with us to testify today, hear cases in immigration court and determine whether to grant relief to respondents who qualify or to issue removal orders, which, in other words, is to deport non-citizens from the United States. It's no exaggeration to say that in many cases, the outcomes of these hearings are a matter of life or death. Yet, as we'll hear today, there are mounting challenges that threaten non-citizens' right to due process and a meaningful opportunity to be heard by an independent arbiter. Today, we'll hear about an immigration court system struggling to deliver timely and fair decisions due in large part to a growing backlog of cases pending before the Executive Office for Immigration Reform, also known as EOIR. We'll hear about children without counsel, sometimes as young as 1 or 2 years old, who appear before immigration judges clutching toys, holding back tears, barely being able to reach a court microphone, but who are nevertheless, under current law, largely expected to make their case for asylum alone. We'll hear about immigration judges who are asked to shoulder impossible workloads of tens of thousands of cases as they face shifting priorities and deadlines, all with little to no support staff. Sadly, these experiences are all too common, representative of a larger, outdated, and overburdened immigration court system that leads to years-long waiting times for removal cases and increasing threats to due process. The head of EOIR recently stated that the case backlog was, quote, the largest single issue facing the immigration courts today. As of August of 2023, there were more than 2.6 million cases pending before the court. The backlog means that some respondents must wait years to have their cases adjudicated. Now, I want to be clear. This is not a Republican or a Democratic issue. The backlog grew every year under President Obama, it grew every year under President Trump, and it continues to grow today. Additionally, because the immigration court system remains housed with the Department of Justice, political appointees from both Republican and Democratic administrations have interfered with the independence of the court. This means that with each new administration, the immigration courts and the attorneys appearing before them experience a whiplash of policy changes and political decisions. Under the prior administration, we witnessed explicitly political appointments and promotions of biased judges, overturned precedent that made it harder for victims of domestic violence and gang violence to qualify for asylum, and case dockets reshuffled to serve a political agenda. Now, unlike in criminal proceedings, respondents in immigration courts also lack the right to a government-appointed counsel if they can't afford representation. Right now, less than half of all people with cases before the immigration courts have attorneys, and an estimated 80% of detained respondents lack representation. And we know that legal representation has a direct and profound impact not just on a respondent's likelihood to win their case, but in increasing the efficiency of the courts. But rather than guarantee representation, we force non-citizens, including children, to navigate through this complex labyrinth of constantly shifting laws, which even immigration lawyers have a hard time keeping up with. The result is that whether from excessive case backlogs, ongoing political influence, or the lack of guaranteed legal representation, our immigration courts risk denying immigrants due process. It's clear that our immigration court system is in desperate need of reform. Now, I can also anticipate some of what my colleagues will share during this hearing. But what about the border? Addressing challenges on our southern border, of course, has to be part of that solution, but it is not the whole solution. As we know, surging resources to enforcement agencies like Border Patrol and ICE without providing necessary resources to EOIR for it to keep up will only further increase the backlog of cases, a natural cause and effect of our immigration court system. Now, as you can see on the chart behind me, the stark resource disparities between immigration enforcement agencies and the immigration courts over the course of the last 20 years. EOIR's budget up a little bit, ICE and CBP's budget up a big amount. The most effective change we can make in Congress to address the critical issues facing our courts is one of resources, but also one where we can pass legislation establishing Article 1 immigration courts. This too would go a long way to restoring judicial independence, due process, and the rule of law in an immigration system. But we also have to make smart investments in immigration courts, including funding for support staff, for immigration judges, for legal counsel to boost representation, and for funding much needed process and technological improvements with the courts. My hope for today's hearing is that my colleagues will come to the table with an open mind, that we can put aside partisan talking points, and that we can focus on what steps we can take together to fix our immigration courts. And to do that, I'm looking forward to hearing from all of our witnesses, from your personal experiences, and what steps you believe can be taken to improve the efficiency of our courts while preserving due process. And with that, looking forward to today's hearing, I now turn it over to Ranking Member Cornyn for his opening statement.
Thank you, Mr. Chairman.